Have you ever wondered if you're always allowed to defend yourself in India? You might be surprised to know that there are situations where the law denies you the right to private defense. Today, we are diving into the shocking exceptions to the right of private defense under Indian law. Stay tuned till the end as I'll also share what you can do if you find yourself in such tricky situations. Let's first summarize what we'll discuss today. First, what's a right to private defense means? 2. Situations where private defense is not allowed. 3. Key case laws and their impact. 4. What you can do when your rights are questioned. 5. Recent updates and legal interpretations. What is a right to private defense? The right to private defense is a legal provision under the Indian Penal Code or IPC that allows individuals to protect themselves and the property from harm. However, this right is not absolute. The law imposes certain limitations to ensure it is not misused. Before diving into the exceptions, let's first understand the concept of private defense and why it exists. Under Section 96 to 106 of the IPC, every citizen has the right to protect their life, body, and property against unlawful acts. But this right comes with a condition. It must be exercised responsibly and without exceeding reasonable limits. For instance, you cannot claim private defense if your actions go beyond what is necessary to neutralize the threat. With the introduction of the Bharatiya Nyaya Sanhita or BNS, the corresponding sections are now Section 34 to 44. These new sections aim to provide a clearer and more structured approach to the right of private defense. For example, Section 34 of the BNS corresponds to Section 96 of the IPC, covering acts done in private defense. Section 38 of the BNS corresponds to Section 100 of the IPC, detailing when the right extends to causing death. This recognition ensures that individuals understand the extent and the limitations of their rights better. Situations where private defense is not allowed. Now that we know the basics, let's explore the scenarios where the right to private defense cannot be exercised. First, against lawful acts. You cannot use private defense against an act that is justified by law. For instance, if a police officer is performing the duty lawfully, you cannot claim self-defense to resist arrest. In Horilal versus State of Uttar Pradesh in 1970, the court ruled that resisting a law arrest does not fall under private defense. 2. In cases of negligible threat. If the threat posed is trivial or not immediate, the law does not permit private defense. For example, shouting or minor verbal abuse does not justify physical retaliation. 3. Provoke situations. If you provoke someone and they react, you cannot claim private defense. For example, starting a fight and then attacking the other person is not protected under the law. 4. When harm is disproportionate, the force used in self-defense must be proportional to the threat faced. Excessive force negates the right to private defense. In Munne Khan versus State of Madhya Pradesh in 1971, it was held that using a deadly weapon against an unarmed person is disproportionate and unjustified. 5. Against state actions. The right to private defense does not apply against acts by the state or its officials, provided those acts are within legal bounds. What to do if your rights is questioned? What happens when you believe your right to private defense has been unfairly denied? Here are some steps you can take. First, understand the law. Familiarize yourself with sections 96 to 106 of the IPC or the corresponding sections of 34 to 44 under the BNS to know your rights and limitations. 2. Collect evidence. If you are accused of exceeding your right, gather evidence to prove proportionality in your actions. 3. Consult a lawyer. Seek legal advice to ensure your defense aligns with the law. 4. File a complaint. If you believe your right was violated unlawfully, Lodge a formal complaint and present your case in court. 5. Educate yourself. Stay updated on changes to the law and landmark judgments that shape the interpretation of private defense. Let's now look at some recent developments and judicial interpretations regarding the right of private defense. In a 2023 judgment, the Supreme Court reiterated that private defense cannot be used as an excuse for premeditated violence. This ruling emphasized the need for immediate and proportionate action. 2. The Bharatiya Nyaya Sanhita or BNS bill proposes significant reforms in the IPC, including clearer definitions of private defense. If passed, this could change how the law is interpreted in the future. 3. In Manoj Pratap Singh versus State of Rajasthan, the court highlighted that even in cases of mistaken identity, private defense cannot justify excessive harm. Let's wrap up today's discussion with a quick recap of what we have learned. First, the right to private defense is governed by Section 96 to 106 of the IPC and Section 34 to 44 of the BNS. 2. It cannot be claimed against lawful acts, trivial threats, or disproportionate harm. 3. Always act within reasonable limits to ensure your actions are justified. 4. Seek legal advice if your right to private defense is questioned. 5. Stay informed about legal updates to protect your rights. If you found this video helpful, don't forget to like, share, and subscribe to our channel for more legal insights. Hit the bell icon to stay updated on our latest uploads. Have questions? Drop them in the comments below and I'll be happy to answer them. See you in the next video. Take care. Bye.